Welcome to this explainer. Look, nobody ever wants to find themselves in this situation. But today we're going to unpack exactly what you need to do when a nursing home completely stonewalls your request for a loved one's medical records. Having the right knowledge in your back pocket can absolutely change the dynamic of this fight.
So let's just be real for a second and validate how truly heartbreaking this is. You've just experienced a sudden death or a severe injury to someone you love in a long-term care facility. You're looking for answers, and out of nowhere, the facility throws up this massive administrative brick wall. They just go completely quiet. And when the facility itself is literally the only witness, getting to the truth can feel absolutely impossible.
We've got a lot of ground to cover today. We're going to break down this complex legal battle into a clear, step-by-step roadmap. We'll hit on hitting the brick wall, the delay tactics they use, your absolute legal rights, the digital audit trail, your action plan, and finally, getting legal help.
Okay, part 1. Hitting the brick wall and when answers just disappear. Following something catastrophic, like a severe pressure ulcer or a really sudden, unexplained decline in health, getting your hands on those documents is absolutely vital. Because here's the reality. That clinical record, it's often the single objective witness to what actually occurred behind those closed doors. So when a facility hides it, whether they shrug and say it's lost or just flat out ignore your calls, they aren't just giving you bad customer service. They are often directly violating federal and state patient transparency laws.
Moving right along to part 2, delay tactics, or as they like to play it, running out the clock.
You know, nursing homes rarely give you a straight no. Instead, they try to just run out the clock with excuses. You'll hear stuff like, oh, sorry, the records are archived off-site, or, well, we're actually going through a big software transition right now. Let's be clear, these are just deeply frustrating bureaucratic lies told to families who are literally just trying to figure out what happened to someone they love.
By actually naming these specific tactics, you can spot the games from a mile away. There's the authorized signatory trap, where they falsely claim you don't have proper power of attorney access, even when the valid documents are sitting right there in their file. Or they'll blame the software transition or some mysterious third-party vendor. Oh, and my personal favorite, the weekend gap, where missing records or missing oversight are conveniently blamed on the weekend shift because, the admin staff was gone.
All right, part 3. Your legal rights and the federal laws backing you up.
It is completely normal to feel powerless here, but let's pivot away from that because you have a massive shield. Enter the Nursing Home Reform Act, also known as OBRA 87. Under this federal law, any facility taking Medicare or Medicaid money has to follow strict transparency rules. No exceptions. This guarantees you or your representative the absolute right to access those records. The law is entirely on your side here.
Now, here's a surprising fact for you regarding the timeline. By federal mandate, you have the right to inspect those records within 24 hours of asking, excluding weekends and holidays, of course. But what if you want physical copies? The facility legally has a maximum of just 48 hours to hand them over. That's literally 2 working days. They do not have weeks to string you along.
Part 4. The digital audit trail and why native electronic data is everything.
So, let's say they finally cave and offer you the records. Often they'll try to just hand you a stack of limited paper printouts. Do not accept them. You must absolutely demand the native electronic records. Why? Because paper printouts can easily omit the crucial context. Native electronic records, on the other hand, contain the metadata. We're talking digital fingerprints, audit trails, deletion logs. This metadata proves exactly who typed a note, when it was altered, and whether a facility straight up ghost wrote care notes days after a fall to cover their tracks.
You might be wondering, how do you actually force them to hand over the digital data? 2 words, HITECH Act. This federal law is a total game changer. If a nursing home keeps electronic records, the HITECH Act legally forces them to give you a copy in that exact native electronic format, including all that juicy metadata that exposes the cover-ups.
And the HITECH Act doesn't just protect the data, it protects your wallet. Facilities used to hit families with these outrageous per-page copying fees, literally pricing them out of finding the truth. Not anymore. The HITECH Act caps the fees they can charge for digital files, usually at a flat rate of just $6.50. It completely dismantles that financial barrier.
Now that you're getting the digital files, what are you actually looking for? Well, watch out specifically for skin and wound flow sheets. Those track the size and staging of bed sores, and CNA flow sheets, which log the really basic daily care like turning a patient or keeping them hydrated. Keep an eagle eye on these because they notoriously go missing. And guess what? Their absence is usually the smoking gun that proves the required care was literally never performed.
Which brings us to Part 5, your step-by-step action plan.
Armed with OBRA 87 and the HITECH Act, here is your tactical battle plan. Stop relying on casual hallway conversations with the staff. You have to escalate this systematically. Step 1. Shoot off a formal demand letter via certified mail. Cite the HITECH Act and OBRA 87 right there in the text. If they try to stall, Step 2. Immediately reach out to your state's long-term care ombudsman. Still nothing? Step 3. File a complaint with the State Department of Health, like the IDOH if you're in Indiana. And finally, Step 4. Drop a federal complaint with the Office for Civil Rights, or OCR, for information blocking.
Finally, Part 6, timelines and getting legal help to beat the clock. The absolute last piece of this puzzle is understanding the incredibly strict deadlines you're up against because timing is everything. Remember, 24 hours to inspect, 48 hours to receive copies. But zooming out a bit, you only have a maximum of 180 days to file that federal OCR complaint for information blocking. And to put it in perspective, using Indiana as an example, there is a very strict 2-year statute of limitations for malpractice and neglect claims. If you let them string you along and you wait too long, you completely lose your right to hold them accountable.
So, what happens when a facility completely refuses to comply and that clock is ticking down? That's when you bring in the heavy legal artillery. An experienced legal advocate can bypass their stonewalling entirely. They can file pre-suit discovery petitions to get actual court orders before a lawsuit even officially begins. They can issue third-party subpoenas straight to the software vendors themselves. And they can use forensic metadata analysis, pairing it with official deficiency reports to dig up the undeniable digital truth.
Which leaves us with this one final thought. Never forget that obscuring the truth is a massive, flashing red flag. Think about it. If a facility is fighting this hard to keep you from seeing a simple clinical record after a catastrophe, what exactly are they trying to hide? Don't let them intimidate you. Use the legal tools and strategies we've outlined in this explainer to stand your ground, break through that brick wall, and force the system to answer for your loved one's care.